because I don't have any proof.
All right, your objection will be overruled in that case.
Okay.
Okay, thank you. Thank you, gentlemen.
Have you excuse, Your Honor?
Yes.
Thank you. Thank you, Your Honor.
You're welcome, Mr. Page. Next, we'll take the Michael Dwayne Wilson case. Could I have appearances, please?
Just observing, but I want to get some.
Good afternoon, Your Honor. Clayton Everett for the creditor in this case and the movement, Straw K Inc. and doing business as A. Arlington storage facility.
Okay. Mr. Wilson, would you appear, please?
Yes, sir. Michael Wilson, appearing pro se, sir.
All right.
Sir.
All right, this is your motion, Mr. Everett. You may proceed.
Your Honor, I had prepared to put on evidence today, but in the interest of time, I can co-offer that, and I have a representative.
I think it would be better if you put on evidence.
Okay. Just to give a little background in this case.
That's all right. I read the pleadings.
Okay.
You can call your first witness.
I will be calling two witnesses. The first witness will be J. Austin, a representative of A. Arlington.
Okay, Mr. Austin, if you'll step over here, the court will put all swearing, and then you may be seated.
Your Honor, if I may approach the bench and the witness.
Yes.
Can you please state your name for the record?
J. Austin.
And who are you appearing on behalf of today?
Straw K Inc. AA, doing business as AA Arlington Abandoned Vehicles.
Are you employed by A. Arlington?
Yes.
What's your position?
Vice President / General Manager.
And how long have you been employed with A. Arlington?
Approximately 15 years.
Can you briefly explain what kind of business A. Arlington is?
We're a licensed towing company and a licensed vehicle storage facility.
Okay. Do you park more than 10 cars out on the lot?
Yes.
Does the debtor, Michael Wilson, owe A. Arlington money?
Yes.
Okay. And what is that based on?
Based on a towing fee and storage fees that have accumulated throughout time. Also based on an impound processing fee and then the taxes.
Is it your understanding that A. Arlington towed the debtor's vehicle?
Yes.
Okay, and approximately when did that tow occur?
June 30th of 2014.
And was this just one of those predatory towing where you just circle around until you find a unmarked car parked somewhere in a parking lot?
No, it wasn't. The vehicle was called in by another business. The vehicle was deemed abandoned, so we towed the vehicle from another business.
And what business contacted you to have the car towed?
It was Vandergriff Chevrolet.
Have you brought your files here today in order to testify from?
Yes.
Okay. Are they kept in the ordinary course of business?
Yes.
And you've reviewed those files?
Yes.
Where was the vehicle transported to?
714 East Division, Arlington, Texas.
And what's at that location?
A storage facility.
Okay. Is the vehicle currently being stored there?
Yes.
Can you please turn to Exhibit 15? Can you identify the document on Exhibit 15?
Yes.
Have you seen this document before?
Yes.
What is it?
It's a notice that we send out, required by the state when we have a vehicle in our storage facility after so many days.
Okay.
After what?
After so many days.
All right.
At what date was this letter sent?
July 2nd, 2014.
Is that within the normal 5 days in which you have to send notice once you receive a car?
Yes.
Okay. And who's the letter addressed to?
Michael D. Wilson.
And the address it was sent to?
3724 Block Drive, apartment 2103, Irving, Texas. And also the letter was sent to Wells Fargo, the lien holder of the vehicle.
Where did you find the address that you sent to?
That address comes from when we tow a vehicle. We run we run a Twix on the vehicle to get the address to see if we can get any information back. So the vehicle, that's the address the vehicle is registered to.
And you run some sort of search, is that with a state agency?
Yes.
Can you tell the court what the applicable towing fees are in this, on this notice?
The tow fee was $217.25. That was the tow fee.
$217.25.
25 cents.
Okay. What about the daily storage fee?
The daily storage fee is $20 a day.
And is there an impoundment fee?
The impound fee is $20.
And a notification fee?
$50.
Now, right below the notification fee, there are two sentences. Could you please read those two sentences out loud? We'll see it starting total storage charges.
Total amount owed as of July 2nd, 2014, $352.05. Total storage charges cannot be computed until vehicle is claimed. The storage charges will accrue daily until vehicle is released. It's 24 hours, 365 days, vehicles will release. Then it has our TDLR number.
Your license numbers then followed, is that what you...
Yes.
Okay. So, as long as the vehicle sitting out there is still incurring more fees, is that correct?
Yes.
And you won't know how much is actually owed until the car is either claimed or sold at auction?
Yes.
Okay. Can you flip to the second page of Exhibit 15, please? Can you identify that document?
This is driver's license of Mr. Michael D. Wilson.
And can you read the address that's on his driver license?
3724 Block Drive, apartment 2103, Irving, Texas.
Is that also the same address that's shown on the letter?
Yes.
Okay. And can you go ahead and look at the next few pages those pages, can you tell that this letter had in fact been sent?
Yes.
Okay. And do you know if the letter was returned?
The first notice to the owner, which is Michael Wilson, was returned and unclaimed, and the lien holder got the letter and signed and received the letter.
Okay.
The second letter, which is the same letter that was sent again, was returned to Michael Wilson, was returned unclaimed, and the lien holder signed and received for the second letter.
At this time, Your Honor, I'd like to offer exhibit number 15 into evidence.
Mr. Wilson, any objection?
Yes, Your Honor.
What's your objection?
My objection is, I never received this documentation, and there's some information that's on there that's inaccurate.
Yeah, I don't think they're saying necessarily that you did receive the document. They're just saying that the document is what it purports to be. And
Yes, sir. They can enter it.
all right, the objection will be overruled. It'll be admitted.
Sir.
Mr. Austin, I believe a moment ago you were telling me that a second notice was actually sent to this. Same address?
Yes.
Okay. Approximately when was that?
July 31st, 2014.
And what's the purpose of sending out these notices?
These notices are required. We're required by state statute to send these notices. The purpose would be to alert the owners or the lien holders that the vehicles have been towed and are in the storage facility.
Once you send the notice to the registered address and it comes back unclaimed, unable to forward, is there any other responsibility you have to send notice?
No.
Okay. When did you first get notice of this bankruptcy case?
Approximately around, I want to say the end of September.
Okay.
So around the end of September, around the 25th, 26th, somewhere around there.
And what were you in the process of doing with the vehicle once you found out that the bankruptcy had been filed?
We actually was in the process of selling the vehicle in the auction. It was ready to go to be sold at the auction.
Did the sale complete?
No, we held it out due to the situation of Mr. Wilson contacting.
Would it be fair to say that you pulled the car from auction as soon as you found out there was a bankruptcy?
Yes, we pulled it.
Okay. Well, has the debtor asked for his vehicle back, to your knowledge?
Yes.
Okay. And why haven't you given the vehicle back?
At the time when he asked, it was over the phone. We felt like he had no right to ask for it back, that it needed to be paid out.
Do you understand that A. Arlington has some sort of lien rights or has some sort of claim to the car itself?
Yes, we feel that we have claim to the car as far as our storage lien rights and as far as our towing fees.
Has the debtor, Mr. Wilson, offered to pay those fees?
No.
If you were to pay those fees, would your company release the car to him?
Yes.
No further questions, Your Honor.
Mr. Wilson?
Yes, sir. Mr. Austin, you mentioned that you contacted Wells Fargo, and on what day was that you contacted them?
July 31st.
And via what method?
Certified mail.
Okay, you contacted certified mail, okay, and was that mail delivered?
Yes.
And in contact with the creditor, what was the response that you received with regards to the status of that vehicle?
I don't understand the question.
What was the response once you sent correspondence to the creditor? What was the response that you received from them?
We just get a return receipt that they received the letter.
Okay. And what letter did you send them?
The same letter that we sent.
And which one is that? Which exhibit is that?
Exhibit 15.
Mm-hmm.
Okay, you've indicated that you were contacted by Vandergrift Chevrolet.
Yes.
To pick up a 2012 Honda Civic from their establishment. Is that correct?
You said 2012
Yes.
or 2010?
Okay, well, according to your sworn affidavit supporting your motion, you indicated that they told you to pick up a 2012 Honda Civic. Yeah, that's what it's right here.
No, it's a 2010.
You go back and look at exhibit number. Once you go look at
Exhibit number 1, I think, is what you're looking for. That's the
the
motion.
exhibit motion for relief on paragraph number 4. Look at that.
Which exhibit?
Read to me paragraph number 4 on exhibit number 1. Paragraph 4. I'm going to read it verbatim. Including VIN number and everything.
Okay, let him read it.
Does it start with Nadine? Start with Nadine?
Where it says on June 30, start there and read all the way to the period of abandon.
On June 30th, 2014, approximately 31 days before debtor filed
You done missed something. Go back, read it again.
on June 30th, 2014,
Keep going.
approximately 31 days before,
You missed something.
21 days.
I want you to read every character that's in there in that paragraph.
Okay,
From
go
start
ahead
to
and
finish.
Gunner,
I'm in charge here. Read what the sentence says and do include everything that is said there. Let him read it. If he makes a mistake along the way, you can call his attention to it after he's done reading, okay?
Very well, sir. Thank you.
Okay.
on June 30th, 2014, approximately 21 days in parentheses, before debtor filed his petition, movement told debtor's 2012 Honda Civic, VIN number 2HGF1B65AH503325 vehicle from Vandergrift Collision, where the vehicle had been stored, upon information and belief. Since 2012, Vandergrift Collision told movement that the vehicle had been abandoned.
Okay, so with that being the case, you swore in your supporting affidavit that all the information here in this motion was true and correct. Am I correct?
Yes.
Okay, and you also swore that you also testified just now that the vehicle identification number within that paragraph is the VIN number from what you were told to tow away from Vandergrift. Am I correct?
We were given a vehicle
Okay,
license.
you said you indicated objection.
What's your objection?
I don't really see the relevance of this. If he's calling attention to minor errors, whether they be dates or numbers, there must be some sort of relevance established before.
Well, I think what he's trying to establish is that the car that they picked up is, or at least the car that they allege they picked up, is not the same car as the one that he owns. And he's welcome to do that.
And in your exhibit number 11, can you turn to exhibit number 11? Mr. Austin, on your exhibit 11, I want you to look at the upper left corner of the vehicle title I want you to read verbatim the vehicle identification number to include all the numeric and alphanumeric characters that's in that list.
2HGF-G1B6-5A-H-503-325.
Okay, Mr. Austin, would it be fair to say that vehicle identification that you just read is different from the vehicle identification that's in paragraph number 4 that you swore that was true?
It looks like the same VIN number to me.
It looks the same. Can you reread that again, please?
Which one you want me to read?
I want you to read the question.
Your Honor, this has been asked.
I want you to read the VIN number.
When he stands up and objects, you have to stop and
Yes,
let him speak, and then you can go on from there.
It's been asked and answered, and if he doesn't like the answer, you can't just keep asking him the question.
It's not the fact that he likes the answer, Your Honor. It's just the fact that he's not reciting what he's reading.
If the numbers are different, I'll be the one to decide that, not him.
Yes, sir. Okay, Mr. Austin, can you please recite to me, if you look at exhibit number 11, what is the year of the vehicle that is indicated on the title?
2010.
And is that vehicle year number different from what's indicated in paragraph? Or the motion?
Yes, it's different.
It's different. Okay, very well. Okay, now, Mr. Austin, you indicated that there was a cost for towing from the facility that asked you to scoop up the 2012 Honda Civic. But approximately, what is the distance between from 714 East Division to where the vehicle was towed from?
I don't know the exact miles.
Okay, estimate. Yes.
I wouldn't be able to tell you.
Okay, but you've towed vehicles for how long now?
For 14, 15 years.
Okay, so would it be fair to say that an estimated distance from where Vandergrift to 714 East Division, would it be fair to say that's less than 2 miles?
I think that would be fair.
That would be fair. So how is it that your cost, when the towing rate for that's listed and as pursuant to orders for as a transported vehicle, how is it $200+ from less than 2 miles? How's that?
We're regulated. Our toll fees are regulated by the state, and we have a max of $250 that we can't go over.
That's not a max. Okay, but you indicate your total.
Let him finish when he starts to answer.
The state has a $250 max on a toll fee. We charge on this particular toll, $217 and some cents. So we didn't go over the state's max.
Okay, what was the now my question is, per miles, if you were to conduct the tow, what is the rate the state regulated rate that you charge per mile to tow a vehicle that's less than 2 tons?
I think, Mr. Wilson, you're asking me about a consent toll. This is a non-consent toll, so we don't charge per mile.
Well, I'm not at that point yet.
What is your normal charge for a toll of this sort?
Is for a non-consent toll?
Yes.
That's the charge.
The normal is $217.25.
We're not allowed to charge.
I understand you couldn't charge $260. I'm just asking you, is this what you would charge for any non-consent tow?
Yes.
All right. Go ahead, Mr. Wilson.
Okay, so if if you notify the lien holder July. Is that correct?
Yes.
Okay, but you got the orders to tow the 2012, a total A 2012 Honda from Vandergrift, which is less than 2 miles, on the 30th of June. Is that correct?
Yes.
Okay, and that's exactly 6 days after a previous filing for Chapter 7 was filed with regard to relief from the courts for myself, right?
Objection, Your Honor, that's a compound question.
Well, it is in your motion, though. It's in your motion.
One person speaks at a time, and if he's got the floor, then you let him speak, and he'll do the same for you. You understand?
Yes, sir.
Okay.
I would just ask that he rephrase the question. It was a compound. I'm not sure I understood it.
Were you aware that he filed for a Chapter 7 before the current case was filed?
Well, I'm aware that he filed Chapter 7 before this case was filed.
Yes.
Chapter 7 is against
Just a bankruptcy.
I'm not sure if I can how to answer that. I'm not sure because
Did you know that he was in bankruptcy at the time you towed the car from Vanderbilt?
not at the time when we told the court. No,
Okay.
if that's the question, no.
All right.
Not on June 30th.
All right.
We haven't received anything.
Okay. Okay.
Okay, so on June 30th, when you how did that go down? They called you up and said that there was a vehicle there that was abandoned and is there without consent. Is that how they went?
The way it works is that a company like Vanderbilt calls us and say they have a vehicle for us to pick up, and we come and pick up the vehicle.
Okay, and did you know that? Okay, you indicated that the company that called you was Vandergrift Chevrolet.
Yes.
Okay, but the documentation here says Vandergrift Collision Center. They're two separate entities.